Hi, my name is Louisa Sidrabat. I'm a liquidator and bankruptcy trustee. So today's question is, what is safe harbour and who is this relevant for? Now, when a company is undergoing a bit of a tough time, as a lot of companies have been recently, they may try and restructure the business to bring it back into profitability or to bring it from low profitability to higher profitability. Usually, there's no guaranteed outcome that any of the actions being undertaken by the board of directors and management of the company will result in the company being either profitable or more profitable. Now, at the same time, the directors of the company have an obligation under the Corporations Act to not trade their company whilst it is insolvent. If it's been loss-making for a while, as well as there being other types of factors present, the directors might consider that the company is at risk of being considered trading while insolvent. Now, if the company is found to be trading whilst insolvent after it goes into liquidation for a period for before the liquidation, those directors can be sued by a liquidator and their personal assets are now on the line, and that can include their family home. Now, directors usually want to try and do everything they can to save the company they're a director of, restructure it, bring it into profitability or further profitability. However, if the risk is that ultimately, if it doesn't work out, that their personal assets and family home could be on the line, this makes them less inclined to want to try a restructure, and they may say at this point, let's just put this company into voluntary administration or liquidation. So this is where safe harbour comes in. Safe harbour provides an opportunity for directors to try and restructure their company without being liable for insolvent trading during that period if it doesn't work out. Now, in order to be eligible for this safe harbour protection from any claim by any future liquidator for insolvent trading now, the directors do need to undertake a certain number of steps and meet certain criteria and do certain actions to be eligible to claim that safe harbour protection. Now, because there's a few steps and the criteria are quite specific, this is something that I do recommend that the directors do together with a professional advisor, such as a registered liquidator, along with a good insolvency solicitor. So, who is safe harbour relevant for? In practice, it tends to be the mid to larger companies and the directors of those companies who are most interested in safe harbour and who it is most relevant to. So while the law is written for this to be applicable to all company directors, in reality, the costs of doing a safe harbour process, along with the costs of the advisors that are required along or recommended as part of the process, it tends to need to be worthwhile for the directors and for the company to pay that money to try and save the company or return it to profitability or return it to further profitability. So if you're a director of a mid to large size company, the company's a little bit wobbly, it might have some cash flow issues, it might be making a loss, or if not for JobKeeper, making a loss, and you're not too sure what to do, but you think you want to try and save the company, but you don't want to put your personal assets on the line, then safe harbour is for you, and it's something that I highly recommend that you find out more about. So feel free to give me a call and I can give you some information about it. No obligations or anything like that, of course, with all the information, and just see if it's something that could be worth doing to protect yourself in case the restructuring doesn't work out, so that your family home and your other personal assets are not on the line if this doesn't go to plan.